Welcome, everyone. If you're taking environmental laws and policies, specifically BSBT 4345, and you're a biotech student focusing on the environment, well, you are exactly where you need to be. I want you to think about your work for a second. You know, the biological systems you study, the ecosystems you analyze, and unfortunately, the pollution that threatens them all, they don't exactly respect lines drawn on a map, do they? So here's the big question. How on earth do we solve the scientific reality of cross-border pollution using international law?
Well, that's exactly what we're going to answer today. Consider this explainer the absolute essential bridge between your hard scientific background and the global legal frameworks that actually govern how your work gets applied in the real world. We are going to break down exactly how nations talk to each other and, sometimes fight with each other over protecting the environment.
Okay, let's dive into this. Here is your roadmap for today's explainer. First, the Environmental Rulebook. Second, hard law versus soft law. Third, the enforcement challenge. Fourth, hard law case studies. Fifth, soft law in action. And finally, number 6, the path forward.
Starting right off with Section 1, the Environmental Rulebook, establishing the scope.
So, before we can even really talk about how international law works, we've got to establish some foundational definitions, just so we're all operating from the exact same baseline. At its core, an environmental law is simply a standard established by a government to manage natural resources and ensure environmental quality. We're talking about everything from air and water pollution to hazardous waste, forests, and wildlife. Now, usually, national laws are adopted by an individual country's government, right? Like federal and state legislation in Malaysia. But here is the crucial point to remember. National actions can escalate to international issues super quickly. For instance, if a Malaysian-owned plantation conducts open burning in Indonesia and that causes a massive transboundary haze right back in Malaysia, well, you aren't just dealing with domestic policy anymore. Suddenly, you're dealing with ASEAN agreements, state responsibility, and the whole shebang of international environmental law. Now, to understand where environmental law fits globally, we really have to draw a sharp line. Over on one side, we have private international law. This deals with contracts between private parties across borders. So say a defective product from a Chinese company injures someone in Malaysia. That is fundamentally a private trade issue. But on the other side, we have public international law. This consists of agreements or treaties among different sovereign nations. In international environmental law, it sits firmly right here on the public side, simply because it focuses entirely on the relations and the agreements between nations.
All right, moving on to Section 2, hard law versus soft law, the two main tools.
This breakdown right here is definitely one you'll want to remember for your exams. Environmental protection relies heavily on both hard and soft law, but honestly, they take very different approaches. Let's look at hard international law first. Hard law is authoritative. It is a legally binding obligation. It's directly enforceable by a national or international body, which means there are actual, real-world sanctions or penalties if it gets breached. We find hard law in things like treaties, customary international law, and UN Security Council resolutions. Soft international law, on the flip side, is much more aspirational. It is not legally binding, and if a nation breaches it, well, no direct legislative action can be taken. Soft law comes from declarations, NGOs, global plans of action, or organizations like the UN Environment Program. Now, you might be wondering, why would anyone ever use soft law if it literally has no teeth? Great question. Well, environmental strategists actually opt for soft law precisely because it isn't binding. It provides a much safer, more accessible global platform for nations to sit down and discuss pressing issues without that immediate fear of legal sanctions. It's about gently influencing them to incorporate these norms into their own national laws over time.
Which brings us to Section 3, the enforcement challenge, the friction of reality.
Okay, here is the harsh truth. Having these laws, whether they're hard or soft on paper, doesn't just magically fix the environment. We are facing what we can call the enforcement paradox. See, most international environmental law consists of general principles that actually oblige countries to adopt their own local implementing legislation. The global laws themselves aren't usually enforceable on their own in court. And why is that? One word, sovereignty. Nations are incredibly reluctant to surrender control over their own territory and affairs to some external international authority. I mean, even when nations do join an agreement, they can sometimes just decline particular parts of it, which obviously immediately weakens the whole thing. And when disputes do happen, Resolving them is a massive hurdle. Even with huge bodies like the International Court of Justice, disputing parties have to voluntarily submit to the court's jurisdiction. It relies entirely on the cooperation of national governments to enforce rulings. And unfortunately, that cooperation is very, very often withheld for economic or political reasons.
Let's get into some specifics in Section 4, Hard Law Case Studies. Messy, high-stakes reality.
So, let's actually apply these legal concepts to the messy, high-stakes realities you'll face as biotech students. Our first hard law example is the ASEAN Agreement on Transboundary Haze Pollution from 2002. At the time, this was a monumental effort. It was the very first regional arrangement binding neighboring states to tackle transboundary haze from land and forest fires. The obligations were pretty clear: cooperate on early warning systems and take legal and administrative measures. But hey, remember that enforcement paradox we literally just talked about? Indonesia, who is obviously a major player in the haze issue, delayed signing the agreement for 12 years due to sovereignty and economic concerns. And the result? Severe haze returned multiple times between 2004 and 2015. To make matters more complicated, Article 27 of this agreement states that disputes shall be settled amicably by consultation or negotiation. Translation? There's no specific legal action stated if the agreement is breached. So yes, it's hard law, but enforcing it is incredibly, incredibly difficult.
Let's look at another major piece of hard law: CITES. That's the Convention of International Trade in Endangered Species, which went into effect back in 1975. Its entire goal is to ensure international trade doesn't threaten the survival of wild animals and plants. We're talking about protecting roughly 5,800 animal species and 30,000 plant species. And this brilliantly illustrates how a treaty organizes protection through a hierarchy of appendices. Appendix I is the strictest. It's for species threatened with extinction, and international commercial trade is outright prohibited. Period. Appendix II covers species that aren't yet threatened, but trade has to be tightly controlled to avoid them becoming threatened. And finally, Appendix III is for species where a specific country actually asks other parties for help with its protection, allowing trade, but with strict regulation.
But here is where CITES connects right back to that idea of sovereignty. CITES itself doesn't actually have specific punishments for wildlife crimes. Each individual country has to enact its own local legislation. To really see the local impact, let's look at Malaysia. Malaysia implements CITES via Act 686, the International Trade in Endangered Species Act of 2008. Listen to this. If you import or export scheduled species without a permit in Malaysia, you face absolutely massive fines. We're talking up to 1 million ringgit for individuals, up to 2 million ringgit for corporate bodies, and up to 7 years imprisonment. So the international treaty sets the standard, absolutely. But it's the local law that provides the teeth.
Moving on, our third hard law example is incredibly relevant to you guys doing biotech waste management: the Basel Convention of 1989. This is literally the most comprehensive global environmental treaty on controlling the transboundary movement of hazardous wastes. The whole objective here is to minimize waste generation and dispose of it as close to the source as physically possible. The convention flat out mandates that you cannot export hazardous waste to states that prohibit its import or to states that haven't given written consent. And I want you to pay really close attention to Article 8. If a waste contract cannot be completed, the state of export is strictly obligated to ensure that the waste is taken back within 90 days, no exceptions.
So, again, how does this international treaty manifest locally? Well, Malaysia ratified the Basel Convention and strictly controls the illegal movement of these wastes locally through Section 34B of the Environmental Quality Act 1974. If you are caught placing, receiving, or even just transiting scheduled waste without approval, it carries a very severe penalty. You're looking at fines up to 500,000 ringgit, or up to 5 years in prison.
Let's shift gears now to Section 5, Soft Law in Action, Guiding the Future.
We've just seen how hard law works, but now let's look at how non-binding soft law actually holds massive power in shaping global environmental policy. A perfect example of this is the Rio Declaration on Environment and Development. Building on ideas from the 1972 UN conference, it defines the rights of people to develop their economies right alongside their responsibilities to safeguard the common environment. It's made up of 27 principles. For instance, Principle 1 basically states people are entitled to a healthy life in harmony with nature. Principle 2 acknowledges that nations absolutely have the right to exploit their own resources, but critically, they have to do it without causing environmental damage beyond their own borders. Now, while breaching these principles isn't directly punishable in an international court, they successfully influence nations all over the world to incorporate these very norms into their own binding national laws.
Just take Principle 16 of the Rio Declaration, for example. It simply states,
The polluter should bear the cost of pollution. Think about that. That is a soft law principle. But this simple, non-binding idea has profoundly influenced actual, hard national legislation and corporate accountability right across the globe. I'm not kidding when I say almost every modern environmental policy you will ever interact with in your career stems directly from this exact soft law principle.
And that brings us to Section 6, the path forward, conclusion.
As we've seen today, environmental protection absolutely requires a combination of both hard and soft laws. Hard laws provide those strict, necessary boundaries, while soft laws build the global consensus we need to navigate those really thorny issues of national sovereignty. Ultimately, for any of these legal frameworks to succeed, nations just have to collaborate and actually fulfill their commitments. But before we wrap up, I really want to leave you with a provocative thought. You guys are the future of environmental biotechnology. You're the ones who will be developing the solutions to clean up pollution, manage waste, and protect our biodiversity. So when your scientific solutions inevitably cross borders, how will you navigate the friction between what the global environment desperately needs and the strict boundaries of national sovereignty? I want you to really keep that question in mind as you continue your studies. Thank you so much for joining me on this explainer. Keep learning, keep questioning, and I'll see you next time.